Imagine a class 8 student opening the social science textbook for the first time in this class and expecting to learn probably about democracy, how courts deliver justice, and how constitution protects citizens. But suddenly, the chapter speaks about the corruption within judiciary itself. And what began as a classroom lesson soon travelled beyond the school walls, reaching straight up to the Supreme Court of India, triggering a constitutional debate not just about textbook but trust, criticism and limits of democratic decision. So this discussion is not merely about a lesson. It is about how citizens should view important institutions and how trust can be maintained there, and if there is a deficit that is being created by an educational institution, what are the limits and powers of the Supreme Court. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand exactly this debate, where it has started from, where it is going to go and every dimension around it. Starting with understanding that what exactly has unfolded. So basically, NCERT in their social science textbook of class 8th had a topic which talked about corruption in judiciary. Now, when Supreme Court got to know about it, they objected to the references that were made about it, and court has clearly termed that this is basically a deep-rooted conspiracy and they are trying to defame judiciary. Now, this is exactly where you will come to think that contempt of court is going to come into the picture. Yes, contempt of court is something that is being considered, but only when it is proven that there is inclusion as of now. However, as of now, the court has ordered corrective action and NCERT will withdraw all the disputed content. But this is not the only reason that this has become a national debate. The national debate, especially from the perspective of a citizen and from the perspective of exam, it is about that how this issue is about institutional legitimacy, because Supreme Court clearly says that what public thinks of this institution is important for their legitimacy, is important for their power, is important for their authority, and this textbook reference is going to erode that. When we talk about constitutional morality and how there can be limits on democratic criticism or public criticism, can an educational institution criticize Supreme Court, the judiciary itself? So this is the debate that hangs on to this particular topic. Now, when we are looking at it, it becomes very important for us to understand when we are talking about constitutional institutions being discussed, being criticized in a negative manner, but how we can assure that the faith in them is not shaken. And if we want a positive criticism to be made, but then we have to ensure that public faith also remains there. So in all this context, we are going to have a discussion starting with when we are talking about all of this scenario, the first thing that we come to think about that judiciary is independent. There is all sort of assurances, provisions at the hand of judiciary. But when we are talking about judicial independence, we have to understand it is a core constitutional principle and how we will be talking about it. So when we are talking about judicial independence, what exactly it is not that judiciary can do whatever it wants. It is the fact that when we are talking about judiciary, they have freedom from executive influence, they have freedom from any legislative pressure, and they also do not to have worried about political or public intimidation. That means there is no way either any wing of the government or the polity setup or the public in general gets to influence judiciary, and they have freedom from all of this. Now, there are multiple constitutional provisions and you will see that these provisions in multiple articles are laid out to make sure that there is so much clarity specifically about judicial independence when we are talking about the constitutional layout. So in this context, when we are talking about constitutional provisions, we get to see especially Article 124 to 147, they clearly lay out the Supreme Court structure and the powers as well. Apart from that, we also get to see that Article 214 to 31, they lay out the same for high courts. And then let's move to Article 32. Article 32 places a huge responsibility on Supreme Court, which puts up it as the enforcer of fundamental rights. Similarly, Article 50 clearly puts separation of judiciary from executive. So there is a very clearly laid out mandate for judiciary which ensures the judicial independence that we are talking about. And if we go back to the Keshwananda Bharti case of 1973, we also get to see that judicial independence has been put as a basic structure part itself. Now one question comes, if that many safeguards are placed with the Supreme Court, with the judiciary, then why judiciary is concerned? Judiciary should not be worried about it. As I mentioned in the starting itself, that judiciary is not worried about their independence. They are worried about the fact, and their concern, as they have highlighted, is that we get the authority, we get the power, the legitimacy of this independence through public faith. We get it and we are dependent on this public trust, not the coercive power that we are exercising. So if this is happening, it is going to erode that, and that is why the courts are concerned. Now this is exactly where another question emerges, that yes, judiciary has the power, judiciary does exercise based on the public trust, but where does this power or where does the court of contempt end or start, and where does the freedom of expression end? So in this context, it is also very important to observe what exactly court has highlighted before we come to talk about where does the freedom of speech end and court of contempt begins or start. So in this context, if we are talking about, when we look what court has said, that as of now, court has labeled it as a serious misconduct which can come within the purview of criminal contempt of court. But court has also said that it will come under this purview only if it is proved that this is a deliberate act to scandalize the judiciary. So there is a possibility, because this has been referenced in the textbook, that contempt of court also comes into the picture. Now this is where we are going to compare both of the scenarios, starting with that what exactly Constitution allows us as citizens. So when we are talking about Article 19, when it talks about freedom of speech and expression, and it includes that freedom, that gives that freedom to academic and institutional criticism as well, that if you have the freedom of speech, then you are allowed to criticize academic setups, then you are allowed to criticize academic setups and institutional setups. But at the same time, in this very fundamental right, we have a limit placed. Article 19(2) permits restrictions which can be placed under the contempt of court. So when we are talking about constitutional contempt powers, Article 29 enables Supreme Court as not just the court of record, but also the one which can take action if there has been issues related to contempt of court. And when we are talking about this power, this is available to high courts as well under Article 215. But when we are looking at the legal standard, Contempt of Courts Act 1971, the legislative statutory backing to it, it has been standardized that criminal contempt includes scandalizing judiciary, lowering court authority and obstructing justice delivery. And as of now, judiciary is saying that yes, it falls in that category if it is proved that it is done intentional. But the question here is, yes, the freedom gives us the right to criticize institutional setups, but at the same time, does this educational critique is just a democratic discussion, or is it scandalizing or disrupting the institution? Where do we understand that? One might just say that we are putting in reference, but Supreme Court has also highlighted in their say that there is no data, no case study which has been backed in terms of the reference that has been given in the textbook itself. So this is where another question must come to your mind, that it seems like there is no way judiciary can be made accountable or criticized at all. But that is not the scenario. Judiciary has to be accountable. If you think judiciary has gone beyond accountability, No, Constitution does gives proper provisions for the same so as to bring them in accountability mechanisms as well. For example, Article 124, Section 4, removal of judges through impeachment process. Judges Inquiry Act of 1968, where investigation framework has also been set up. Internal in-house inquiry mechanisms are also present as well. So this clearly shows there are provisions, but at the same time they are limited because we have structural concerns such as high judicial dependency. There is limited transparency when we are talking about appointments, and ethical misconduct allegations do keep surfacing here and now. So this is where we need to screen this out, understand the challenges and put addressal to them, be it the judiciary itself taking the step and put it right, so that there is nothing as such to criticize, but if the public, if the institutions want to do so, where is the line drawn? That remains the main core issue here. Now that we have understood that what exactly has unfolded, I would like to bring another important dimension here is about the fact, can a court actually intervene when we are talking about educational content? Isn't that about separation of powers? How does Supreme Court get to enter in this scenario? Now when we take first thing in our mind, the first thing that we need to talk about here is the educational autonomy. So if we go by Article 19 itself, so if we go by Article 19(1)(a) which talks about expression, Article 21(a) which talks about right to education, we get to see that curriculum development is clearly linked to these freedoms itself, the fundamental rights which have been set. Now, but when we are talking about pedagogical dilemma, that means what we are teaching kids. In that context, you have to think, should we teach them to place trust in the institution, or should we tell them to understand, analyze and criticize, to encourage early thinking, early analysis, what? And when we are looking at the separation of power dimension, we get to clearly understand that it is an executive body, NCERT, which framed the curriculum. Judiciary intervened through constitutional authority itself. So when we are talking about relevant doctrine, we have to couple Article 50 with judicial interpretation, which comes to separation of power. We can also take example of Indira Nehru Gandhi versus Raja Narain 1975 case, which affirmed its basic structure as well, that Article 50 clubbed with judicial interpretation leads up to separation of power. But this directly raises concerns about judicial intervention in the policy making space as well. And this is where we enter the simple yet the largest democratic debate, that what should we do? Should we focus on trust or should we focus on transparency? Now, what are your thoughts on this? Let me know in the comment section. That was all from my side. Thank you so much.